Oh, yeah, among other things.
All right. Okay, welcome everybody. Since it's 1 o'clock, we'll get started. Oops, I'm sorry. Okay, sorry, trying to figure out the microphone here. Okay, welcome to today's event, a debate on should the U.S. copy the EU's new privacy law. My name is Kim Hart. I am managing editor at Axios. I've been covering tech policy for about a decade, and before this I was press secretary at the FCC under Chairman Tom Wheeler. So there's lots of privacy stuff going on there as well. So I'll kick this off and then we'll get right to the debate, and at the end we'll be opening it up to questions from the audience as well as from Twitter for those following along remotely. In May, the General Data Protection Regulation took effect in the EU, but its ripple effects spread far wider than Europe's borders, and it impacts companies that touch consumer data across the world. Since then, privacy advocates have urged U.S. policymakers to take the same approach and to pass an American version of the data protection legislation, modeled after the GDPR. They say strong rules are necessary to force major companies to take consumers' data rights seriously. Critics of GDPR and of a U.S. copycat policy say that these regulations are extremely costly for companies and will degrade the consumer experience online and discourage people from using these services altogether. But the conversation has heated up, largely spurred by Facebook's Cambridge Analytica data leak scandal and other reports detailing how major tech companies in particular collect personal data even when consumers aren't using their services. But action is starting to happen. Some states, including California, have put in place their own privacy rules. This morning, the Trump administration, through NTIA, proposed 8 possible areas of outcome for comment. And tomorrow, the Senate Commerce Committee is holding a hearing on the topic. Today, we'll explore this more deeply in a debate between advocates on both sides. A quick note about the format of today's event before we get started. We're going to start out with 15 minutes each hearing from the opposite sides of the issue. Then we'll end up with allowing 10 minutes to respond to each side, and then a quick follow-up after that. And then we'll turn to the last 20 to 30 minutes or so. We'll make sure we turn to questions. For those following along, we're both live streaming and live tweeting with the hashtag ITIF privacy. If you do have questions that you want to submit from those watching the live stream, please use that hashtag, and we'll try to get to them at the end of the Q&A session. So before we get started with today's discussion, by a show of hands in the room, do you think that the U.S. should follow Europe's direction on data privacy? All those who think yes, the U.S. should follow the EU's lead, could you raise your hand just so we get a show of where people are? All right. And those who are no? And it seems we have some undecided as well in the room. Okay, so we'll get right to the debate. First, we're going to hear from, well, I'll introduce everyone on the panel first so we know who we're hearing from, and then we'll jump right into the debate. I'll start from my right. On the far right, we have Daniel Castro. He's the Vice President at the Information Technology and Innovation Foundation and is Director at ITIF's Center for Data Innovation. He was previously an analyst at the Government Accountability Office. To my right, we have Will Reinhart, Director of Technology and Innovation Policy at the American Action Forum. He was previously a Research Fellow at Tech Freedom. To my left, Justin Brookman, Director of Privacy and Technology Policy for Consumers Union. Previously, he was Policy Director at the FTC's Office of Technology Research and Investigation. And Amy Stepanovich, U.S. Policy Manager and Global Policy Counsel at Access Now. Previously, she worked at the Electronic Privacy Information Center on these issues, too. So we're going to start first with the positive case for U.S. to adopt a GDPR-like privacy legislation, heard by my friends over here.
Thanks, Kim. So I'm going to take the first part. Thank you. Thanks, Will and Dan for debating with us. Thanks, everyone, for showing up to debate privacy legislation, something near and dear to my heart. Though I do feel like in some ways the debate has kind of, the conversation's already kind of passed this debate over, right? It seems like everyone now seems to agree that we need some degree of privacy legislation. Earlier this month, we saw major trade associations for the first time saying, yeah, we obviously need something. What we've done so far hasn't been sufficient, right? So the Internet Association, Business Software Alliance, even the Chamber of Commerce saying we now need privacy legislation. Just last night, we saw Google come out with privacy principles for legislation. And it wasn't just like hand-waving saying accountability and self-regulation. It was like, no, there need to be affirmative legislated restrictions on how information is collected, used, and retained. And you saw during the Cambridge Analytica hearings that Kim referenced that, you saw several conservative anti-regulation Republicans saying, you know what, we probably need some GDPR-like protections here in the United States because what we have right here isn't sufficient. I mean, this isn't the 1990s anymore when everyone was like, the internet's awesome, let's not do anything. Like, what could possibly go wrong on the internet? I think we now recognize that maybe we made some poor choices a while ago, and now we're trying to retrofit on some protections, maybe a little bit too late, but I do think that the vast majority of people now recognize that something needs to change. And I would argue that most things that we would have in privacy legislation really aren't or certainly shouldn't be controversial, like transparency. We should make more information available about what's going on. Right now, if I wanted to choose between the Washington Post app or the New York Times app or the Axios app and wanted to consider privacy, I would have no information about how to do that. I really couldn't make an informed decision. The markets for personal information really aren't working right now. I work at Consumer Reports. This is something that we're trying to do. We try to evaluate products and services on lots of things, but including on privacy and security. But there are a lot of things in the space that are just not observable or measurable. So, if something gets stored in the cloud, how do I know if it gets sold or transferred or lost or that? That's not observable. That's not knowable. I can try to look at their privacy policy and try to figure out what they're doing, but privacy policies aren't very helpful. They tend to be very vague reservations of rights. There might be a clause saying we reserve the right to share information with certain business partners, something that's actually hard to evaluate and figure out what's going on. It's difficult for Consumer Reports to do, and we do this for a living. It's certainly not scalable for any average person then to try to do that in order to make informed choices. So I don't think anyone in this room would really disagree with the premise that notice and choice, which is how privacy's been done, is really a charade, right? It's neither notice nor choice today. So there certainly needs to be some sort of information, some sort of mechanism to convey meaningful information to the marketplace about what's going on. And we can talk about what that looks like. Maybe it's like SEC type filings. Privacy policies need to be a lot more detailed, so maybe not average person needs to read them, but I can read them, and the FTC can read them, and the press can read them to get a sense of what's going on. Maybe it's icons or simplified notice, but certainly something needs to be. We need to find some way to put more information into the marketplace, because you can't say the markets work, but there's no opportunity for price discovery, which is how it is today with personal information. Data access, interoperability, portability, so you can see what people know about you. You can take your data to a competing service. Again, this might have been a controversial notion 10 years ago, but now everyone seems to be agreed. Well, yeah, they should tell you what's going on. And competition policy, maybe we haven't gotten it right, so we need to make it easier for people to port their information between services. Again, this is not crazy privacy advocates advocating for this. This is the Internet Association and the Chamber of Commerce. Security, right? You should use reasonable security to safeguard data from inadvertent loss or disclosure, proportionate to the sensitivity of the data. It needs to be reasonable, doesn't need to be ultimate. I don't know what the counter argument to that is, that companies should be entitled to use unreasonable security means. The law kind of reflects that today, but it's not clear, and having that written down with clear penalties for violation, I think would be a positive step. I think the hardest part about privacy law is like the choice and control. What reasonable defaults should be. What's opt-in, what's opt-out, what sort of things are just off limits. How do you legislate design? How do you legislate away from dark patterns? So the OK button isn't bright blue glowing, and the skip button is off in the corner and moves around a little bit. That's the hard part. I mean, that involves how much regulation should there be? There are trade-offs, and it's hard, but that's the debate we should really be having. Not should something need to change in the first place. I feel like it's that comic of the dog drinking coffee in the room burning, and we're having the debate is this okay? I would say it's pretty clearly not, right? I mean, we're obviously not fine today. People have no idea what's happening with their personal information. There's no expectations of trust for any connected service or platform. going back to the Brandeis writing about privacy in 1890, his original formulation of privacy was that it was the right to be left alone. And for him, he was worried about cameras, right? People are going to be walking around taking pictures of everyone. They kind of lose their sense of control. And the thing is, it wasn't really scalable yet back in 1890, right? There really weren't enough cameras to track everyone 24/7, even for a future Supreme Court justice. It just wasn't enough of it. He wasn't wrong. He was just early. Now, the dystopia that he was worried about is now technologically possible. So, we watch TV, and our television now reports back what we're watching to the manufacturer and heaven knows who else. Insurance companies want to install us all with Fitbits so they can monitor how many steps we take every day. That are monitoring our grocery store purchases. Our cars want to log all the places that we drive to and want to start showing behavioral ads on our infotainment screens. I do a search for a medical condition at work, and then maybe that night at home I'll get an ad for a related product, or maybe I'll see that ad on my television. Companies are now looking for ways to charge us different prices based on information, right? Uber does this. We may be pulling up the same ride. I'll get a different price. And maybe that's based on my own usage patterns, and maybe that's first-party data, and that's okay, and that's understandable, though there are not a lot of choices. Maybe it's not. But what if it's based on things that maybe it probably shouldn't know, like my battery life? Maybe it should be able to access data brokerage records about me in order to try to figure out how much I'd be willing to pay. Should they be able to know how much I just spent on a cup of coffee to decide how much to charge me for a ride home? And in a world of increasing corporate concentration, companies more and more have the ability to engage in this sort of first-degree price discrimination, leveraging informational imbalances. At the FTC hearing last week, if you watched it, Nobel laureate Joseph Stiglitz warned precisely about this. And in a world of increasing inequality and diminishing individual purchasing power, loss of privacy will only really exacerbate these problems. Privacy alone can't solve these problems. We need to do lots of other things, rigorous competition enforcement, getting rich people to pay their taxes, but privacy is an essential part of it. And if you look at privacy surveys, right, people desperately want more privacy, but they hear about all these things that I just laid off right out, and they don't know what to do, right? They throw up their hands in frustration. There's this sense of fatigue, and I don't know what to do. I wish that things were better, but I don't know how to make it better. They don't have any agency or trust. And so I think we need to find a way to try to accord people's reasonable expectations with what actual practices are. But that doesn't happen today, right? Companies are able to free ride on people's lack of awareness as far as what is going on. There's no accountability for bad practices because they're invisible, and as a result, we really don't have that right to be left alone. And so I think there's some sort of consensus that we've gotten off the tracks a little bit. And to argue that privacy law is somehow incompatible with American values is obviously not right. We've had some degree of privacy law for depending on how you count, 50 or maybe 100 years. We had the Fair Credit Reporting Act. We have Section 5 of the FTC Act. It's clearly just not been enough. But a lot of the values we discussed earlier are kind of reflected in existing law, but not very clearly or consistently. We have a few sectoral laws in certain niche areas, but for the most part, it's the Federal Trade Commission and state attorneys general using general purpose consumer protection statutes from 100 years ago and trying to apply it to a set of problems that wasn't really widely recognized at the time. Like Brandeis got it, he saw where it was going, but that was not what Section 5 was written for. And I love the Federal Trade Commission. As Kim said, I spent a couple of years there. I think it does a really good job with the tools that it has, but it's not up to task with the current tool set. There's far too little staff there today to police an $18 trillion economy. And they don't just do privacy, right? They do competition, and they probably should be doing more there. They do fraud. They look at influencers who are peddling snake oil on Instagram. Privacy is just a small part of what they do. They have half the staff of what they had in 1980, and the economy is nearly 3 times as large. And other agencies are increasingly fobbing off their responsibilities to the FTC. So Kim mentioned the FCC had been doing stuff on privacy, and then they were like, nah, let the FTC handle it with their weaker laws. They'll be fine. Clearly, the FTC needs more resources to address that, and privacy legislation needs to include that. FTC doesn't have the ability to get penalties today when someone breaks the law. So most times when someone gets caught doing something, they just have to sign an order saying, okay, we won't do that again in the future. Clearly not enough consequences to deter a lot of these practices. And and they clearly need more substantive authority too, right? Unfair and deceptive acts and practices authority is necessary, but it's certainly not sufficient. Deception, like, yes, companies should not lie about what they do. But when that's the primary way we enforce privacy law, it creates a strong disincentive for companies to actually say anything. So you see these broad privacy policies that are non-specific and reserve really broad rights to do stuff, but it's actually hard to get a sense of what's actually going on. Privacy policies today are not designed to convey actionable information. They're designed to insulate companies from liability. And then we have Unfairness Authority, which is interesting, right? And the FTC has used it in a couple of privacy cases in fairly aggressive ways to try to say, no, that's not what people would expect, and they obviously can't avoid it. But even in the security space, they've used it since 1995 or so. It's being attacked in courts, right? They lost in the 11th Circuit in LabMD. D-Link is suing them or is resisting a case on what I think are fairly straightforward bad privacy practices. And then there's a question, what is substantial injury in the privacy space? I think that conceptually you could conceive of pretty broad ideas of injury, but the law is not specific, again, because the law was not written with this in place. Does it get to things like intrusion upon seclusion? Does it get to things like loss of autonomy? Commissioner Olhausen at the FTC hearing a couple weeks ago seemed to think it should, but would the courts agree? I don't know. Price discrimination, right? I mean, yeah, I would worry about companies collecting information about me to take more part of the consumer surplus away from me. Is that harm? Is that the sort of thing that law was designed to get to? I don't think so. In any event, the FTC doesn't have the manpower to aggressively wield its unfairness authority that way. So what do we have today? We have the failed notice and choice framework, where companies don't need to tell you what's going on and actually have strong incentives not to tell you what's going on. A lot of services offer opt-out tools, but they're not really manageable. I mean, people shouldn't be expected to manage 100 different companies' opt-out settings. Even Facebook alone has myriad settings that are incredibly confusing. I consider myself a relative expert in privacy and Facebook's privacy settings, and I don't know what they do. And they constantly shift and they change, and sometimes they don't work as expected. Google, for example, a couple weeks ago, there's news about how they had location history. If you turn it off, it doesn't actually stop Google from collecting location history about you. You can try to do self-help, you can try to install ad blockers, and I do, but ultimately, that's just going to escalate the war, and it actually then moves a lot of the tracking offline in ways that are completely unobservable to you. I think not a great end state where people are fighting the war of all against all for personal information. We've seen some halting industry efforts around self-regulation, but they obviously haven't done the trick. As a veteran of the do not track process, you're going to have a hard time convincing me that the industry is going to come up with good faith solutions that actually work. Instead, 20 years later, online behavioral advertising is still governed by this weak industry opt-out regime. They use the ad choices icon that no one recognizes that actually see less and less of anymore. The rules don't apply to anyone, and more companies aren't in the trade associations, and they actually don't even work. I mean, if you're one of the few people like me who goes to the DAA, NAI opt-out pages and try to do it, it's like a 20 to 30% error rate. And other industries are actually probably worse, right? The data broker industry. They had a trade association like about 10 years ago, IERSC, I don't know, but I think hasn't been extant for about 10 years now. And so, if you ask, what are the standards by which the data broker industry collects and uses and sells personal information? I have no idea, and I don't think anyone else does either. So I think some sort of legislative privacy protections, I think we can all agree upon. And to maybe preemptively push back where I think Will and Dan might go, that privacy will then kill the internet that we love, I think it's worth pointing out that most of the really cool stuff that we see online really doesn't rely on bad privacy practices, right? Like, Google search works really well. They use first-party data, they serve first-party ads. Similarly, Gmail, YouTube don't rely on bringing in a lot of external data. Facebook, they inexplicably do a lot of crazy things on privacy, but the core product is again, all first-party data usage and collection, which I think people find intuitive. Streaming music, Uber, Apple obviously goes out of their way to market themselves as very pro-privacy. I don't think you need unbounded data collection to make cool products, but unbounded data collection is, I think, where we're headed, right? I mean, we didn't have the tech before, but now everything's connected to the internet. Everything has sensors. And our physical walls aren't going to hold it back, right? The sensors are in our homes, even if the technology, and if it doesn't, like the technology exists to see through them, right? And remember the Kylo case from the 90s, a Supreme Court case where the cops would go up to a wall and wave a wand and see whether there's heat emanating from it, which is an indication of growing loss of marijuana. These wands are now like $5. And in the government space, I think the courts have increasingly said that even if data is collectible, right, without observable by the cops, there surely should be limits on how it's collected and how it's observed. So in the Kylo case, they said, no, you shouldn't be outside the person's home waving a wand, try to get a sense of what's going on. You shouldn't bringing drug dogs right to the porch, try to sniff and see what's going on. The Jones case, right, a person going around in public, 24/7, observable, right? But the court said, no, we don't really expect that someone's going to be watching us all the time. And I think we need to kind of import some of those ideas to the commercial privacy area too.
20 seconds left.
20 seconds, okay, good. So let me end with like the prototypical privacy issue that a lot of people worry about, which is Facebook listening to me on my phone. I don't think they do it today because it's too hard, but one day soon they might be able to, and lots of other people might be able to too. There are definitely people who are trying to do this. And I guess the question is, should they be able to do that without my knowledge or control or anything? I would say no, that maybe they would say yes, like they'll learn lots of cool stuff about you and they'll be able to serve ads, and where's the harm? I would argue that's contrary to how we expect our products to work. I think there should be basic protections over that, but I look forward to hearing the rebuttal.
Thank you, Justin. So I'll turn it over to Daniel. Is it Will? Will you be ready doing the rebuttal? All right. We'll make the case for why the regulations that Justin just laid out are not necessary.
That's a lot. I mean, I've got about a half a page of notes on that. So I kind of prepared a bit of a different rebuttal, which was mainly looking at the GDPR and thinking about it within context, seeing what's happened in the EU privacy scene, what we've seen since the implementation in May, and just kind of thinking through, okay, what, if these are extreme cases, which I think there is actually a really, really good case that GDPR implementation really is or can be an extreme case for a lot of privacy protections, what that actually means for the ecosystem, what it means for choice. I guess as a first matter, I wouldn't necessarily say we have unbounded data collection right now, because there are at least some sorts, as Justin rightly pointed out, there are some sorts of control rights that we do have over these, over our collection within certain kinds of platforms like Google and Facebook. But I do want to focus at least on some of the things that the GDPR does really poorly. There were 5 things that in a couple pieces that I really highlighted. One of them was that data collection and use must be minimized by any means necessary, which is likely to limit secondary usage and stifle startups. I think that's something that we could talk about a little bit more further. Second, the users must affirmatively consent to all data processing, a costly requirement that doesn't really give consumers any more options, but forces them to choose every single time whether or not they want to have information processed. The third major area is that consumers generally have the right to export their data. I know we can probably talk about this a little bit later, but I'm not exactly convinced that that is the panacea and even a really good solution, because they basically already exist. And then fourth, that consumers can force the delisting of information, the kind of the right to be forgotten. But what really supports all of this, and what really I think has gotten a lot of people worried, is that if any of these provisions, and it's a pretty long document, the GDPR, if any of the provisions are violated, there's a set of very onerous fines that are applied, which could include up to 4% of global revenue, which is pretty massive. So the stick here is pretty big, and what has happened is that firms and companies really have tried to understand this new set of regulatory risks and have undertaken a huge amount of change in their own internal processes in order to deal with it. Now, what this means, and so I want to at least highlight some of these processes. These are the clear costs that we know so far that have come with the implementation of GDPR. So generally speaking, the GDPR implements, or at least causes, 3 types of general costs on companies, and there's other costs that consumers themselves bear. Companies generally have to retool their processes. That means they have to basically redo data lines. potentially redesign some of the processes and the, some of the data processing and data processing methods that they're engaged in. The second thing is that there's a general increase in risk compliance. So that is another big issue. And then the third is that the entire industry largely changes. So, we haven't really seen a lot of great econometric studies come out, primarily because it's just way too early, since, we need some months and some time period to see what actually happens to firms in these kind of regulatory contexts. And the more years that we have before and after the implementation of a privacy regulation like GDPR is actually extremely beneficial. Still, the IAPP, and again, it's IAPP, they estimated along with Ernst & Young that for the Fortune 500 companies that were involved, it cost them around $7.8 billion to just kind of retool and get into compliance. This was, these were fixed costs that had to be borne by the companies that had to comply with the GDPR. PwC found that some 88% of companies surveyed spent more than $1 million on GDPR preparations, and 40% of them spent more than $10 million. Now, these come largely in having to retool your own processes, having, as I mentioned, having to change around the kind of internal organization that you're engaged in, and that's not cheap by any means. What also comes with that is a general change in the risk perception of investors for these types of industries, and we have seen this before. So, for example, when there was the last e-privacy change with the European Union, that we actually did see a pretty dramatic decrease in the ad-supported and specifically news content sites that have proliferated in the United States. So these kind of effects do clearly occur. There are clearly compliance costs. There are clearly costs that that firms have to bear because of this. Now, the question is whether or not that in this overall calculus that, there is a general benefit. Because we could say, okay, yeah, at the end of the day, companies should have to bear these costs, because what you gain is that consumers have the ability to exercise, rights. And I do concede that, largely speaking, that ubiquitous and extensive data collection does impact certain aspects of how people understand their agency and how they understand their relationship to the world. So I'm not blind to that, but I think that we have to think about these types of rules as far as optimality is concerned. Are the kinds of things that GDPR did? I mean, perhaps we do want to have some sort of federal law, which again we can talk about, but that it doesn't necessarily have the contours of the GDPR. That it doesn't suffer all of the problems that GDPR actually suffered. Now, I am hesitant again about the benefits of these items, but I think that we should consider this overall conversation as part of that type of framework about about the costs and the benefits that both consumers and consumers and firms have to bear in order to implement this law writ large. So the question then comes, well, okay, if consumers do, there are a lot of surveys about what consumers perceive or understand are the detriments of the current large-scale collection of information, and yet there seems to be always this tension between these two sorts of elements. One is that when you survey, and Pew's done some really, really interesting surveys on how consumers believe that they've benefited or not from the internet. Generally speaking, most people think that on net they've benefited more from the access to information on the internet as compared to not. And there's been a couple again Pew surveys specifically asking these kinds of questions. Have the information that you get on the internet and cell phone services, these types of online connected platforms, have they benefited you personally? And generally speaking, most people think that yes, that on net they think it's been a pretty good benefit from them. Where we, I think, are really concerned, and where I think there is rightful concern, is, well, how do we solve these problems that we've talked about? I mean, the problems that we've mentioned here are, as we kind of mentioned, Cambridge Analytica. How exactly do you solve necessarily that problem at the very beginning? And again, I think we should talk about that a little bit more fully. That the Cambridge Analytica problem was in some ways kind of a third-party contract problem, which gets into a bit of a different and sticky issue here, that in fact the issue wasn't necessarily between Facebook and the consumers, but it was between Facebook's contract and understanding with Cambridge Analytica and Cambridge Analytica's then third-party selling, or this, this technically is actually a professor who was collecting information. So there's a set of contextual facts that I think that we really need to understand at the end of the day. That to me really does make the GDPR style regulatory policy quite unappealing, because again, you have these opt-in systems that I think are quite onerous without necessarily giving consumers more information. You have a very onerous fine system, which generally makes the entire sector far more risky as an investment. With this, I think that Justin was generally right, that some of the best actors aren't doing the nefarious things that we would like to see. They're mainly first-party contracting. That most of the information is, almost all the information is staying kind of on on these platforms. But then I guess then the question becomes, well, what is it? What are the problems that we're exactly trying to solve? And I think that for me, that really is the question that I think we have to ask. What are the problems that we're trying to solve? And generally, do those solutions actually benefit consumers more?
Great. So just to follow up real quick, just for understanding, because I think both sides win it a slightly different way. Understand, Will, that you are not, you actually think a GDPR-like policy would be detrimental in a lot of ways.
Yes, I think that is clearly the case. The GDPR-like system could be very detrimental. But again,
baseline, another sort of privacy legislation could be worth discussing. That maybe doesn't
I'm up for
go
negotiation
far.
on that.
Okay.
I could be convinced in the best case scenario, but again, I still think that there's some very serious questions about what exactly the baseline scenario solves and
where we're trying to get
exactly, yeah. and what is it? What are the solutions and what exactly are the problems we're trying to solve there?
Got it. Okay.
So maybe we're in agreement then, because you usually said you guys want to come debate GDPR. We said we both have problems with GDPR. We'll argue comprehensive legislation. Then you titled the problem should we copy EU new privacy law. So maybe we're actually fairly closer than we thought.
So I just want to clarify. So we all agree no GDPR in the U.S.
Copying and pasting GDPR to the United States, no, sure.
That's
I can link you to the blog post where I wrote that down publicly.
Proof.
You can all read.
So maybe we should shift in the rebuttal, Amy, or Justin, whoever kind of takes the next round. Maybe we can shift the question to what are the problems that we're trying to solve and that need to be solved? Because I think that's where we will see some differences from both sides.
Yes.
Absolutely, and I'm glad that all got reiterated, because that's where I was going to start, is that the GDPR, which was something that we very much supported, we have an office in Brussels, it's one of the 12 offices that Axios now has all over the world, was written in a very specific context with years and years of case law and history and definitions that the United States does not have. And so importing a law that was written for one jurisdiction and writing it into a new jurisdiction will cause problems that the United States isn't willing or able or prepared to solve, and will not solve the problems that I think we need to get to solve. And if I were to answer Will's question, it would be things like discrimination, which is something that Justin brought up, fraud, identity theft, and manipulation, which are activities that are occurring on the internet every day, that are things that users don't want to engage in or have their data used, ways in which they don't want to have their data used. And they're things that data protection law can go a long way towards solving. And so then you get into what should be in data protection law. And then, as Justin also said, there's a lot of agreement there, which is a really wonderful thing. This conversation, and I have been working in this area not as long as many people, and when I started, we were still having the debate, should data protection even be a thing? And I attended, I can't even count how many panels where people said no and people said yes. Now we are in a space where people largely agree, in a world where Brazil, India, the entire European Union, hundreds of data protection laws around the world. It's not only that the United States doesn't have a data protection law, it's that people in the United States are being left behind in an area where the rest of the world is having their government assert and protect certain rights vis-a-vis private industry to protect against those harms that I started out enumerating. And people in the US do not yet have a system that is built to anticipate not only where technology is now, but where technology is rapidly heading. As Justin indicated, we're going into a world with the Internet of Things. How many of you don't have to raise your hands, but just think for a second how many of you have some sort of IoT device in your life somewhere that's not your cell phone, because IoT has a complicated definition, which we all recognize. So it's as our digital lives, our physical lives, our online shopping, and our in-store shopping, as all of those become more intertwined, and it becomes easier to conduct the granular individual manipulation discrimination that Justin explained, getting toward a world of data protection is actually going to protect from future harms. And it has to be written in a way that isn't specific to the tech we have now, but actually is broader, more encompassing, and will provide specific, clear standards for companies to grow and adapt to. And so one of the things that I think many of us, my app is updating, so all of my notes are currently in tech limbo.
I need regulation now.
So one of the things that I think that we've talked a lot about in the data protection space is the idea of consent and the idea of when people and how people should operate in a consent-based system. I think that's going to be one of the issues that we continue to argue about in the future. Yep. Is it opt-in? Is it opt-out? Where do you give it? This notion of how many of you received 50,000 emails when GDPR went into effect with all the updated privacy policies? We don't want to live in that system. But imagine companies were complying with GDPR, because one of the things that I think we need to all recognize is 90% of GDPR was in the 95 directive. It was all there. It didn't really change the legal system all that much. It just changed the fines for non-compliance, which made companies all want to run and say, now we have to figure out how to comply with this law that we always knew existed. And so then we got all of this rush of changes for corporate policies. If we had a law 10 years ago in the United States, so imagine when I started in the privacy space, we weren't fighting about whether or not we had a law, we were fighting about what was in it, and we eventually got something passed. The immediate rush to have to change business practices, to have to update for compliance, to have to do all of those things that cost money that Will enumerated, that would have already been done. If we don't act on this now, what's going to happen, more companies are getting into the tech space. You have companies that did refrigerators 10 years ago. They only did refrigerators. That was their sole practice in life, is to build really good refrigerators that kept your food fresh. And now they're connected to the internet. Number of internet connected companies are growing at an alarming rate. And so if we wait for any longer to put in place data protection practices, you're going to have more companies build themselves for a system that has no data protection law, and the costs of increased compliance, those costs of changing business practices, those are just going to go up. We could have taken this action a long time ago and been past this already, been past those growing pains. Regulation comes with growing pains. We all know that. There are costs of compliance. It increased costs. It has huge benefits as well. And I know there's arguments about the size of the benefits, the size of the cost. That's another place that we probably are going to argue about a lot. But there are, it will move us forward, and we can get past it if we're in a place where we're talking honestly about what should be in a law. And so that's where I would put us moving forward, is to say things like, should we be talking about right to be forgotten? Will brought up the right to be forgotten, which I think is a really interesting argument to have. The right to be forgotten, something I like to explain to people, because I needed it explained to me several times over by our European staff, who really got sick of me after a while. It's two different rights. The right to be forgotten is not one thing that everybody should hate. It is two different things. One thing is the right to deletion. I have the right to, if I want to leave a service where I'm currently a member, I use Twitter, my handle's on the wall. If I no longer want to use Twitter, I should be able to go to Twitter and say, delete all of my data you have about me. I no longer want to use your service. That is a right in the GDPR. Take all my data out of your system. I'm not going to be a customer of yours anymore, and we can both go about our ways. That's a part of the right to be forgotten. The controversial part, and this is the reason that you have to separate them, is because this part tends to be less controversial than the right to erasure, which is the right to say, when somebody searches for Amy Stepanovich, here are the news stories I don't want to come up in that Google search anymore. Not that they can't come up at all, but they can't come up in relation to my name. That becomes really controversial. That's going to be something that groups want to see in the United States. We have personally said we don't want to see that in the United States. We're not a fan. We actually oppose it in most jurisdictions. It's very easy to abuse. But that will be another area of controversy, and it becomes really important at that point to get the details right, to understand what we're talking about, and understand why we don't want to be that written into law. So I will leave with, I'm optimistic about where we are, because we have already in 39 minutes gotten significantly past what we thought we were going to be fighting on. It means that we have hope that we're going to get somewhere else. Maybe a few of you will raise your hands at the end when they ask if you think we should have data protection in the United States more than at the beginning. And that is where I think we can move forward.
Thank you, Amy. So, Daniel, will you be doing the next rebuttal?
Yeah.
So, I guess to push us along is, do you agree with the problems that we're trying to solve, some of them that Amy laid out, and do you have another set that, a frame through which you're looking at this?
Yeah, no, that was actually really interesting. Amy laid out discrimination, fraud, ID theft, and manipulation. I think those are areas that people are legitimately concerned about, but I think when you look at how the privacy debate is being shaped right now, when people are talking about privacy legislation, when you look at how it's been approached in the past, that's not, the privacy problem people claim they're trying to solve. People are saying, they're concerned about Facebook, and they're not concerned about discrimination on Facebook. They're saying they don't like that Facebook has my data, and we should create a law for that. And so I think if we separate out those two problems, that's a really good thing.
You're saying sector, like a company specific?
Well, that, it's not, the concern isn't, does a data broker have my data? The concern is, am I experiencing consumer harm from some type of fraud or identity theft? Those are very different problems, and they're often conflated together. And I think a lot of the data protection laws we see aren't trying to address the fraud issue and the identity theft issue, and I think that's part of the problem. I think if we're talking about what data protection laws should look like, first of all, as Will said, they should be actually solving a real problem. And so we need to be very clear about what that problem is. They should also, not be harming consumers. They shouldn't have a negative impact on innovation, and they shouldn't be burdening the companies with compliance costs. And I want to kind of fill in some of the details of how we're seeing that play out, because I think when we start talking about what do we do in the U.S., we have to be aware of how that looks in other countries. So, GDPR, when we looked at that and we saw the costs there, and I guess one difference between us and Axios now is we oppose GDPR for Europe too, not just for the U.S. And I think it's important that it's not that it was. I don't think it was good in Europe either. It's not that it was just bad for us. But the cost here can't be understated. So there have been a number of estimates for the Fortune Global 500 companies. The cost of compliance for GDPR was $7.8 billion on one estimate. PwC surveyed 200 companies of 500 or larger, and 2/3 were planning on spending between $1 and $10 million to meet GDPR. Another 9% were going to be spending $10 million. So together, if you look at 19,000 U.S. firms, that was $150 billion in compliance for GDPR. The ongoing costs are substantial here too, right? So it's even those deleting upon request, that can be a good thing, but it can also cost companies a lot to figure out how to comply with that. And the challenge here is, how do they enforce the compliance? It's the risk of fines, which we know are substantial. It's 4% of gross revenue or 20 million, and this hits the small firms especially hard. And so large companies are more able to weather this kind of fine, which creates the problem of, okay, so are you going to be hurting the startups the most? And I think that's one thing that people are particularly sensitive about. there's also the issue of, how these costs are manifest. So after GDPR, Reuters reported that there were 1,000 U.S.-based news sites from the LA Times, Chicago Tribune that weren't accessible in the EU. Washington Post, I think even still today, you can go on and they have an EU premium account, which is 50% more. You have to pay 50% more if you're coming from the EU because of the costs associated with it. And this matters, all these costs matters, because policymakers should be asking, do consumers actually want to pay more for privacy? And if you go back to all the academic research, that there's been a lot in this space, consistently, when they actually do these studies with consumers, they don't want to pay. So there was a great study, and we went through a bunch of these in a recent report, but there was one that really stuck out to me. It was it involved a bunch of German participants. They had 2 online stores, and they were asked to buy a DVD from one of the 2 stores, and they were selling them for the same price. But one of them had this privacy invasive survey that they had to take if they wanted to buy it. The starting place was, consumers were buying equally from both stores when the DVDs were the same price. If they offered even a small discount, it was a very small discount, everyone wanted to buy from the privacy invasive one because consumers simply just wanted the cheaper option. And so policymakers shouldn't be forcing consumers to move into this world if that's not the choice they would willingly make. Will talked a lot about how GDPR impedes innovation. I think a lot of these principles, data minimization, purpose specification, we hear these come up a lot in the U.S. context. It gets to the compliance issues because it's this issue of are we going to have data protection officers complying with it? I don't think it's enough to say, well, if we pay for it now, we won't have to pay for it later, because a lot of these costs are ongoing, and there's no way to really just kind of minimize them today. We also have to look at how it's, I think, creating a bad consumer experience. Will talked about how opt-in's so messy for consumers. It's a bad experience. Even today, we're seeing more of these interstitials, which I think is really interesting because, it was about 3 years ago that Google had done a lot of consumer experience research on this, and they said consumers dislike interstitials so much that we're going to factor that into our search ranking algorithm. So if a website has interstitials, we're going to bump you down. Of course, now all these European sites have to have it, but we already kind of knew that consumers don't like them, and we know they weren't reading these policies, so now we're kind of forcing them to agree that they've read these policies. The compliance cost here and the kind of experience is so bad. I wanted to show, what was so interesting to me is, all these, we got these opt-in emails. We also got opt-in letters from people. Here's one opt-in letter we got from this German association. And they said, according to GDPR, we want to reconfirm that you'd like to get our newsletter that they send to us electronically. But they're mailing us, a paper document from Germany, along with the form to fill out, which, we're going to have to handwrite, and they want us to mail it back, and someone's going to type it back in. But they did include a QR code because they're really concerned about efficiency. But, it's this kind of bizarre idea that, but it always manifests in a lot of these rules that, opt-in and, getting consent, it sounds good as a principle, but this is what it actually looks like in practice. And so we have to be really careful about how we do that. And the last point I really want to get to is that, it's not really clear that these type of laws are going to be effective. So, Amy made a great point about, the GDPR didn't really change the legal system all that much. And I mostly agree with that. And, obviously, Europe's argued for a long time that they had stronger data protection levels. But, if you look at trust levels in all these countries, and there's been a lot of surveys on this, a lot of studies, consistently, the levels are basically the same. UK, 71% of respondents in a global survey said that they, had trust in the internet. France was 68. The US was 68. They're all at the same levels. And you even go to countries that have less data protection, Nigeria, South Africa, they were at the same levels, around 70%. So, the last part I just want to mention is that we also have to still, I think, keep asking, do consumers what are we trying to solve here? Do consumers actually want more privacy? And so, consistently, NTIA has been doing these surveys, through the Census Bureau, asking these questions. And, in the most recent one, NTIA found decreasing levels of concern in 2017 compared to 2015 in terms of, consumer concern about privacy. And we've seen this kind of consistently drop. We've seen consumers say that, their willingness, they're willing to, use devices, they're willing to get on the internet, and privacy isn't impeding them from doing that. And we're actually seeing this in Europe too. And so the question is, what is the actual problem we're trying to solve? And if the problem is identity theft, then let's talk about other solutions that can have a bigger impact in there, like stop using social security numbers and these types of issues. So I think it's really important that we narrowly define what the problem is and how we go about doing it, because, otherwise, I think it's too easy to start talking about, well, we're going to have some new privacy laws, and suddenly it starts looking a lot like GDPR, even though we say that's not what we're going to do. I don't think if you would have asked the Europeans 5 years ago, are they going to make a GDPR that has really high costs for compliance, has all these negative effects on consumers, they would have said that's what they were going to do. I think this was an accident, and that's the problem. I think in this space, it's very easy to make privacy law. It's very hard to make good privacy law.
Okay, so thank you, Daniel. On that point, we'll get to a few questions, and I'll open it up to audience questions. Hang on one second. I have a couple for the sides, and then I'll open it up. But I like your eagerness. So I guess going off of what Daniel just said with, maybe we are trying to solve too broad of a problem, and does it ring true to either of you that starting with some tailored approaches or sector-specific approaches is the best route, or does that just end up going down rabbit holes that don't apply broadly enough to get to your point, Amy, about trying to future-proof this a little bit, and not just for look at what we're doing right now, but the problems that we can't even understand yet because of the Internet of Things hasn't fully arrived yet, and whatnot.
I will let Justin answer this as well, but I don't think we can say the sector-specific approach, which is the approach the U.S. has taken, has maybe fended off harms in specific industries, has maybe helped protect specific populations, and for that I'm thinking about children. We have a children's privacy law. But it has not done its job in protecting privacy or providing for a level of data protection for people in the United States. And it won't do the job of keeping up with the global climate toward data protection as we, again, watch other countries implement these systems and we increasingly get left behind. And so I would say, and it's also not, if the goal is keeping compliance costs down for companies, it's also not preventing that, because companies are investing in these compliance costs, again, for every other regime. It really is just keeping protection down in this country. Justin?
Yeah, I mean, I think, look, I'll take what I can get. I mean, there are some of the sectoral laws, like the Video Privacy Protection Act, have done a pretty good job. But I mean, I would not narrowly constrain it to just, I'm just worried about identity theft, and if we pass something to address the social security numbers, then we're done. I would also push back on the idea that longitudinally people are less concerned about privacy. We're actually working on a paper that's kind of studied attitudes over time, and I think that by and large the trend lines are people getting more and more worried. But I think we do need to do things to address things like excess data collection that's unexpected, right? People are fine with Google and Facebook, like on those platforms. Should Google know every single website I go to and every single app that I use? I would say not, right? I mean, same with Facebook. I think there should be rules around that. The data broker industry, I mean, I think people don't like if you have a relationship with someone, they're going to sell information about your purchases to someone else. I think there should be some more clear rules around that. Like the Internet of Things, right? Is this phone listening to me? I don't think so, but I don't want to look side-eye all my products all the time to worry about, what's going on. I think people have reasonable expectations about how things should work, and I think the law should try to align expectations with practices.
And there is, I think everyone agreed at some point in their remarks that there is a certain opaqueness about how data is used or shared or collected, and I know transparency was one thing that got brought up on this side. I didn't hear it mentioned specifically over here, but is something that is simply making sure that consumers, if they are interested, can understand all the different data brokers or third-party vendors like a Cambridge Analytica, that they would be able to understand who has access to their data and which data is being used, and even the price that was paid for that data, to kind of assign a value to it, which I know is an idea that has been thrown around a little bit in kind of broader, vague terms. So the idea of transparency, and if that could be a first step that people can agree to.
I'll start with that. I mean, I think transparency, is a principle that has, existed since the California law. And I think it's a generally one of the best principles out there. It's the idea of informed consumer. I think that's how you have notice and choice. I mean, that's the regime we have now. I think it does make sense to, if we're going to, I think the U.S. right now, Justin earlier said everyone agrees we need privacy legislation, and I might even be in that camp, but it's not because I think, 5 years, that I would say 5 years ago we needed privacy legislation. It's because, right now the U.S. is basically under attack from GDPR and from California, and so the question is, well, we need to do something because otherwise we're going to have, 50 states create their own rules and have really high costs. And Europe's going to be setting the rules of the road for the whole global internet, and those are both really bad rules. So we better create some new rules that fend off those rules. It's not really that we're saying, oh, there's this, again, kind of this inherent privacy problem that hasn't been addressed. So I think that's a key part of this. And so if we look at what has been working, the transparency part has worked really well, but there's a lot more data out there right now, and so there's questions about, well, how can we make it more efficient for consumers to understand this, who want to understand, but also, not putting in, again, really onerous requirements on companies, because in a fast-paced environment, it's hard to, and you don't want it to be a compliance cost that's unnecessary. If one person wants to know, you have a new data partner. Do you have to first give 30 days notice so you can try and slow down the innovation life cycle because of that?
And okay, go ahead.
I was just going to mention something because I think these two issues are actually related. One of this question of opaqueness and something that Amy mentioned, which is this manipulation, which is something that I think actually the reason why we care about this and the reason why GDPR seems to have come at kind of an opportune moment, kind of weirdly enough, is because the conversation in the United States, and I've been kind of in a research role in doing this now for working on network analysis for now a decade, and for the very first time, this is the real, this last year has been the only or has been really the kind of the moments that people seem to care about these issues in a way that the general public, if I were to go and talk to somebody about privacy regulation and GDPR, you actually can't have an interesting conversation. And that's not to be, the point of this is that Cambridge Analytica, I think, really set off this really weird conversation that we're currently in, because, as Amy mentioned, this question about manipulation to me has always been this push and pull between advertisers and marketers who are trying to tout the benefit of their platform, and Facebook and Google who think that they're exceptionally effective, and yet when you look at the data on how effective these platforms are at, changing consumer intentions, and a previous life I actually was a marketer and did research on this as well, and it's not really as effective as you would think it was going to be. Political campaign persuasion also doesn't really seem to be all that effective. There's mostly null effects when you have these kind of broad, big meta research studies. I think Brendan Nyhan, who's had a number of pieces in the New York Times, has kind of taken a lot of people to task on exactly this issue. But the manipulation question about Cambridge Analytica still comes into these kind of fundamental American concerns about democracy, about controlling your own destiny, which are hugely fundamental. So I don't necessarily think we can get away from them. But at the same time, I think that there is clearly an inherent connectedness between this kind of opaqueness question that we're trying to solve, and this idea that each individual needs to be an empowered individual, and really those tensions that actually exist when you're talking about real live human beings engaging in platforms.
I'll just say, respond that, the transparency, I think Dan was saying, transparency's worked great, but it hasn't, right? No one really knows what's going on. California has a law saying you need to have a privacy policy. It doesn't say you need to have anything interesting in it, right? You can say your privacy policy is puppies are great, and that's it. And then, you don't learn anything about what's actually going on. So even your example of the German study, right? People might be willing to do a privacy invasive study in order to get a discount. They can't. That's not happening in the United States today. We don't know when we're taking that privacy invasive survey right now. At the very least, I think we need to do a lot more to get anywhere close to that level of transparency so people can make decisions. I think we can go further and set defaults based on expectations. But at the very least, I want to push back on the idea that we're there on transparency.
A couple things. Cambridge Analytica has been brought up a couple times, and Will, you asked about if it was a Facebook Cambridge Analytica problem or a problem with the users. And so I want to bring up a little bit of a point related to that, because the facts of Cambridge Analytica frequently get lost of what happened. And there were 2 levels of intrusion that happened there. There was Facebook sending a lot of user data from users to the apps, the people who generate the apps that they use, and then the contract that went on between Alexander Kogan, who developed the app, and Cambridge Analytica, that piece, which is a direct line between users interacting with an application and that application selling data. That has one level. The second level is they didn't only send those users information, they sent the information of all of those users' friends, their entire network. And so there were a lot of people who were not involved with Kogan or Cambridge Analytica who were on Facebook who had their information transferred over. And that, to me, is a Facebook problem. It's a problem that I think Facebook recognized because very shortly thereafter, they stopped allowing that data to go to third-party app developers. Now, I would have argued it never should have gone to begin with, and people should have been able to understand, and notice and transparency would have gone a long way to educating people that that was going on. And then real quick, one other thing that we have asked for in transparency, specifically in response to this Cambridge Analytica matter, and I don't know to what extent it will be useful. I've had, by the way, a lot of really, really fascinating conversations on privacy with people throughout the United States, and I might spend more time outside of DC than a lot of people who live in DC. Is we are looking for some sort of notice about transfer of information to third parties. If I use a service and I contracted the service and I have some sort of relationship with a company or a service, and they decide to, on the back end, send my information out to 20 other companies, I should have some sort of knowledge about who those people are. It shouldn't just be a throwaway statement in a privacy policy, which is exactly what we get now. We can send your information to third parties for whatever purposes we decide, essentially. And so I should have a list about who they're sending my information to, and if it changes, I should get updated on it. And even if that doesn't mean anything to me as an average user of a service, there are companies out there, organizations like the one Justin works for, who will be able to aggregate that, who will be able to tell people stories about how their data is getting used, and that information will be very valuable in these policy conversations and going back to users on a macro level, even if on the micro level they don't use it as much.
Just one small comment about Facebook, and I don't want to keep on focusing on this, but the question. I actually used to run as part of a, when I was an RA, we actually had a day where you would, build your own little app and basically, use the Facebook profile allowances and collect literally all the information about your friends and create a small little network, a social network map. This is back in 2009, I guess it would have been in grad school, which is when they first allowed it through the API. That quickly changed when it was actually pretty evident that marketers were using it for other purposes, and it was very clear at that time that it was being used for other purposes. It is kind of, as I said, just kind of interesting that now we're talking about it, because they shut it down and they deprecated it in 2014, and now we're here, 4 years later talking about it. So there is this. It does take time to obviously have the kinds of changes that we're talking about, but I'll just leave it at that. I think that there's some interesting tensions that I think that we need to suss out again, as I mentioned, about what exactly we're trying to solve. I mean, if we're trying to solve these discrimination, fraud, identity theft, and manipulation problems, I think that we could probably do a lot of other means, or there are a lot of other means that we could engage in order to solve them. And I really just want to see what the primary problem is and what exactly, and I think you just mentioned one actually, that potential legislation could actually solve.
And to say, those are 4 problems. I don't want to say that I am identifying every single problem that we're trying to solve for the entire community.
If I can just jump in, we did a piece, really early this year after the Cambridge Analytica, where we talked about data misuse, and we actually called for updating the data breach laws and saying that data breach laws as currently defined are probably too limited, and that going further and saying, look, we don't want to restrict companies from sharing data with third parties, but if they say this is how data is going to be used, they give it to a third party, and the third party uses it in a way that isn't in line with how they said it's going to be used, that's a problem, and that they need to be held accountable for that, and data breach laws should be updated to reflect that. So I just want to say that's potentially an area of agreement, and I think it gets to one of those real issues that people actually care about. But the goal shouldn't be to limit the data sharing. It's about holding companies accountable for not using data in ways that they say they're using it.
So I have a lot more questions, but I want to get to the audience before I move on. So, gentleman in the yellow shirt, and someone is going to have a microphone. If you could just introduce yourself before you ask the question and speak into the microphone so the people on the live stream can hear.
Sure. I'm Mark McCarthy with the Software and Information Industry Association. And I want to confirm, by the way, that industry is on board for a national privacy law. We've gotten there. I see Amy going yes. And it may not be just because the atmosphere has changed because of GDPR and because of California. Consumers want it. I mean that's a very important thing to take into account, and industry will benefit from it around the world because we're now at a disadvantage. We seem to be coming from a country where privacy isn't fully protected. And the U.S. itself can benefit because it can restore its privacy leadership around the world. It's slipping away to Europe and Brazil and India. Going forward with something is a good idea. And I'm very, very pleased by the tone of the discussion because it looked as though there were large areas of agreement. The magic, I think, was not so much in the discussion of transparency and choice and deletion and all that, because I think those have to be elements of a new privacy law. The progress was in a discussion that focused on particular problems. I think both Justin and Amy focused on various issues. Justin, you talked about price discrimination. Amy, you're talking about discrimination and identity theft and fraud and manipulation. The way forward might be to think of an element of the new privacy law as being just a straight statement that the unreasonable collection, dissemination, and use of personal information is a consumer protection problem. Bring it under Section 5 of the FTC Act and allow the FTC to take steps to enforce those kind of things. Justin's a little nervous about that because he doesn't think it goes far enough. But what that means is that we may need to have a serious discussion about what kind of harms should fall into that bucket. I, for example, wouldn't want to put price discrimination in there. I think personalized pricing has lots of advantages. I mean, it provides people who don't have a lot of money the opportunity to buy things that they couldn't afford. But let's have that conversation. I wouldn't put discrimination against protected classes in that group because we have laws that cover that right now, enforced by the EEOC and the banking regulators. But that's the kind of conversation. What kind of harmful practices belong in the bucket that should be taken into account when we move forward on new privacy legislation? That, I think, is the real area where we can make some progress.
Thank you. That does raise one question, though. If we're talking about possibly rethinking what the harms are, and then putting those under the umbrella of Section 5, and then that puts it under the purview of the FTC. Going back to what Justin spoke about earlier about does the FTC have the tools or the resources to exercise those tools seems to be the obvious next question.
Yeah, so obviously you would need to considerably beef up the FTC. There's been a lot of talk about creating a Bureau of Technology, maybe coming out of the office that I was in that started in 2015 or so. Lots more staff in order to bring cases in Civil Penalty Authority. But yeah, I think the FTC is probably the right institution to do it. I worry about from consumer point of view, I worry about the what's the harm question because when I lose data, I have what do you call it, harm or injury, or I have an interest in that data, right? If someone collects information about me, I no longer have control over it, and I can legitimately worry how it can be misused or how it could be used to my detriment down the road, right? It could be, we can debate about price discrimination, but in mass, it could lead to more part of the consumer surplus being collected by the companies, less by individuals. It could be breached going down the road. I could legitimately worry about that, right? Government access, right? If government, especially in non-rule of law type jurisdictions, could access it in ways that I have a legitimate reason to care about. And so I worry about if no protections will apply unless I can demonstrate how I will be harmed by it. I would say, per se, there is a legitimate worry that data collected could be used against you in the future. So that I think that, if we're going to do a risk-based framework, I would say that there is always some degree of risk.
Open it up. Was there another question right here?
Carl Zabo with NetChoice. Justin, you and I both worked at the FTC. You know, unfairness is pretty broad. So lack of terms in privacy policy can be unfair. Missing material terms can be unfair. Do you think that Section 5 as it exists would address a lot of the concerns you raised? And the other thing I wanted to ask was data breach laws and the law that you helped write, Justin, in California only apply to businesses. Should we apply it more broadly to nonprofits who also amass great amounts of data? And what would the cost be on those nonprofits to comply with these laws?
So unfairness maybe, like, I mean, as I said, unfairness is incredibly fluffy. I mean, I don't know. I mean, it can go, it's very vague. I think it would be better to lay out in a new statute what should be done rather than trying to litigate in the courts for 20 years as far as what unfairness might mean. I think it'd just be better, like, if we think that the law should say something, let's have the law say something and not try to rely on unfairness. In the meantime, I certainly advise the FTC to do more with its Unfairness Authority. Worked on the Vizio case, for example. As far as nonprofits, I think it reasonably could apply to nonprofits. They do collect sensitive information. You know, I will push back on, like, you know, the tremendous compliance costs that people. I think one limitation of GDPR is actually it favors process over substance, or at least the way it's been interpreted, right? So, like, you know, like, just send out, you know, 40 new updates, you know, update your privacy policy, hire new people, but you don't actually change what you're doing. I would actually reverse that, where I think the privacy legislation less in terms of process and more in terms of, like, substance. Here's what the actual rules are. So I would say the way that GDPR have been interpreted is not actually at all what privacy advocates ever asked for or what the drafters of it intended to be. They never wanted, like, cookie shades on screens or people getting, you know, 40,000 emails. That was not what they asked for. You know, Google and Facebook pushing you through a somewhat coercive consent process is I think wildly contrary to actually the terms of GDPR. We'll see if European regulators actually do enforce it. Like, as you know, they don't have a great history, right? Since '95, the laws have been there, and they actually haven't done much. But I would prefer to see a law that favors, you know, lays out clear rules for what you can do, and you don't have to have like a massive accountability program where you have, like, 40 data protection lawyers on staff to try to just document every single practice. I mean, I think that's great for IAPP and it's great for privacy lawyers. I'm not sure it's great for consumers.
I just want to respond quickly on both why I definitely don't think the FTC's current authority is not enough, but also to Mark's question, why I don't think actually expanding that without giving affirmative rights is the right approach. And that's narratively because Facebook was already under a consent order with the FTC when Cambridge Analytica happened, and we saw no indication that in any of the audits or assessments or whatever you want to call them, depending on what government document you're reading, that anything happened, that they were able to even understand that this lack of deletion of data, that the deletion of data hadn't occurred, which was the key precipitating factor, let alone take action on that. I don't think the system we have, absent affirmative rights, is going to go far enough. And then just real quick on nonprofits, absolutely. Our position is nonprofits should be encompassed, and Axios now is fully GDPR compliant, and we would welcome becoming compliant with any stronger laws the United States wanted to put into place.
I just mentioned, I mean, you know, Cambridge Analytica, UK-based company, and as you said before, you know, these laws have been on the books. It's not just GDPR. So the European laws also didn't solve the Cambridge Analytica problem, which is, I think, why when we're saying today, well, you know, how much do we want to copy what Europe's done in terms of stricter rules? The question is it actually going to solve the problem that most of us actually care about, the most recent one being Cambridge Analytica?
I do have some small concerns with FTC expansion, and this has been mentioned elsewhere before. I mean, the kind of case law that you're describing doesn't, I mean, it exists kind of, but not really. I mean, it goes, you know, whenever you appeal, it goes to an administrative law judge. So, I mean, is it going before, you know, we're only now just having LabMD. When it's now at the 11th Circuit. I mean, we're now really just having the very first true privacy case going to the courts, you know, full court, in the way that you would want to see privacy law kind of develop, at least in that sense, through the FTC. So that's my major concern with the FTC. The other thing that we really haven't talked a lot about is this kind of lingering question of the First Amendment. And, you know, I mean, it is still out there. You know, when Justin mentions that, you know, that somebody is collecting information about you, that necessarily implicates First Amendment and commercial free speech issues. And I don't think that's kind of the lingering question that we really haven't talked about today, but it is clearly implicit in this.
To follow up on that, Will, if the FTC may not be fully equipped yet, especially as case law continues to be developed, and obviously the FTC has different rulemaking authority than other agencies do as well. Is there a regulator or a body that you think would be better equipped, or like on its own or in partnership with the FTC, or a new way to imagine how a enforcement framework might work?
Personally, I would just like to see some reforms of the FTC. I mean, I could be convinced otherwise, and I think that's a big lift. I mean, I just don't think it's going to happen. But I mean, FTC really is the place where you'd want this kind of enforcement. They've been doing it for some time. They've been doing it since GeoCities. So there's been a long history at the FTC of dealing with privacy concerns, and I don't think that there are any other regulatory agencies that really can do it in the manner that the FTC can. So that may look like reform, or maybe it's just that we kind of continue the way that we have in this kind of non-law space that we're in, as I think that Randy Picker talked about.
If you want the FTC to litigate more cases, then you absolutely need to give them a lot more resources, right? Litigation is hard and expensive. 1 or 2 cases will shut down the Privacy Bureau, right? And so if you really want to develop that body of case law, then you need to be committed to giving them the ability to do it.
Another question? I think you had one, sir. Right up here.
Kevin Murnane's contributor for Forbes. Although the cost of compliance is just one element of this really complex problem, we've had a lot of information about the estimated or perhaps measured cost of compliance for companies for dealing with some of these compliance issues that are raised by the GDPR. What we haven't heard anything about is any data about the cost of the consequences of dealing with data breaches and harm that has come to individuals and consumers, when oftentimes the individuals who experience monetary costs from these problems are orders of magnitude less able to actually survive or deal with those consequences. Do you have any numbers about the cost for users and consumers to compare with the costs for corporate entities? How much is it costing people?
The cost of informational injuries is, if you had a good study on that, you would probably be well cited by a number of people. I mean, I've been trying to think through how you'd actually do those kinds of calculations. There are other sorts of calculations that look at how much benefit do people get from the use of general services, which is typically counted by the amount of time that they spend on platforms and devices, and then effectively just estimates from there from the average median wage. That's usually around the $1 trillion mark. As far as the actual costs are concerned, that's a really difficult question, because what you're actually asking for is what would people be willing to give up in those instances for that harm to not occur. And as we've seen, we haven't really gone through a lot of the willingness to pay and willingness to buy survey, but these vary quite considerably depending on how the preferences are structured, how people understand what has been lost and what they can gain. So it's not an easy way. I don't think that there's a clear-cut way to really separate out those costs, to be very honest.
So what I was asking about was, has anybody done any? Has data been gathered about costs that actually have been incurred by people through things like data breaches? You just don't know?
I mean, there have been costs. There have been, a number of studies on data breaches, but when you're talking about privacy, that's a bit different than the data breach question. So those are related, but a little separate. I mean, one could think about breach of any database, but whether or not these certain kind of informational harms, like, I'll let other people talk about it, but there's a bit of a distinction to be made there when you're talking about data breach quantification as compared to a privacy harm quantification.
There are numbers that I do not know off the top of my head, admittedly, on costs of recovery for individuals from certain data breaches. For example, the Target data breach, how much time, money it took to cancel things, recover, if financial loss occurred to people. Those numbers exist. I can probably find them with some Google searching, but I don't know them off the top of my head. One area that numbers don't exist, actually, that I think is more complicated, more interesting, and that we've been calling for research on that nobody has done yet, is the non-financial, where numbers aren't readily available, where there's not necessarily financial harm from data breaches, but where there's undeniably harm. And the reason why we think that's so important is because most data breach notifications, so getting out of data protection laws for a second, most data breach notification laws are tied specifically to financial information. If your credit card number gets leaked, or your social security number, something about identity theft, which is an issue we talked about. In the Internet of Things world, that's not taking into account the vast amounts of personal data that people don't want to be breached, and they want to be notified if it's breached. It doesn't fall under these data breach notification laws. And if we start figuring out costs to people of if these different types of non-financial data get released, we also can then start looking at how to help people recover, which is another area I don't even begin to know the answer of. The reputational harms, the emotional harms, the problems if somebody takes my credit card, I know how to cancel my credit card. I know how to create a new credit card. I know how to change all my accounts. It's a big headache. If somebody takes photos off of my phone of my family, I don't necessarily know how to fix that. And I think we need to be investing in this non-financial space a lot more, where there aren't numbers to study.
Other questions?
Hello, Rachel Pfeffer, Congressional Research Service. I wanted to build off that last question, and we've talked about privacy, and then Amy's used the terms data protection a lot. Kind of where do you see those overlapping, and where do you see those as distinct? And where should the maybe federal regulation or framework, as we start to think about it, fall?
I'll be candid. I've never understood the distinction. When people in Europe talk about data protection, I don't quite understand how they're using that term magically to not mean privacy. So I mean, when I think of privacy, I think of the fair information practices like transparency, and I think of that as, and I think maybe a data protection maybe is more narrowly about security. I mean, I think we definitely need security legislation as part of overall privacy framework, but I think we have to get to the other pieces too. Maybe you can explain to me how people in Europe mean data protection.
Privacy, I'm now pulling from human rights documents that I don't have in front of me. Privacy is generally freedom from interference with your personal life, whereas data protection is protection vis-a-vis processing of data. And so they very much relate to one another. And in Europe, at least, where you have a fundamental right to data protection, that applies in the government sense, the nonprofit sense, the corporate sense. The GDPR applies in every sector. It's not only companies. In the United States, frequently the distinction you'll hear, where there is no fundamental right to data protection, is privacy is a right you have vis-a-vis the government. It's a Fourth Amendment right, where there is no corporate, you don't have a Fourth Amendment right against corporations. And data protection rights would be something that you would have in that private sector processing. Sometimes the government gets looped into that, but privacy is very much a Fourth Amendment piece, which would be separate.
I just add, in the current conversation, I think it is helpful to think about data rights in general as opposed to thinking about privacy, because then we can talk about some of the issues that people are asking now. One about data breach, but also data access issues, data portability, and I think that's a more productive conversation, because then you're talking about how are we both protecting consumers and empowering consumers with their data, as opposed to doing it in this privacy rights-based framework, which doesn't always align with just the way I think people think about these issues and the way that it comes into tension with other issues like First Amendment or other things.
Other questions? We have a few more minutes.
So we recently did polling that showed 3-to-1 Americans prefer ad-based advertising to paying for content. It's the same advertising that pays for services on Axios or Consumer Reports or over at Forbes. What's the impact that eliminating the effectiveness of interest-based ads, and what effect would it have on reporters, the ability of free sites, and would we be likely to see more paywalls get erected, creating a further divide in the digital economy?
Of course, data protection does not prevent advertising. I run into this actually very similar argument in the law enforcement space a lot when we tell people that law enforcement should have gotten a warrant, and they're like, you don't want cops to catch bad guys. And we're like, no, we do. We just think there should have been some process first. Data protection doesn't prevent advertising as a first matter. As a second matter, I think one of the things that we come to is the pay for privacy aspect is very predatory, particularly toward marginalized populations. And if you're incentivizing that model, you're actually going to further harm the populations that we support data protection to most protect. And I would like to see some of those populations more represented in public conversations like this one. It's a very similar request that I made when I had a very similar session at IGF USA this year. And so I would like to see those populations included in these conversations to hear what they have to say in answer to this question. But one of the things that we have, another one of the things I talked about, transparency for third-party transfers, that we've asked for in our data protection framework that we've laid out is some sort of program to incentivize companies to pursue business models that aren't based in data. And that doesn't have to be one or the other. It doesn't have to be you pay for the service or you get very invasive, horrible advertising. There are different business practices that could be out there. If we're going to have companies get fined for, we're going to have a data protection law where companies can get fined for manipulating data in ways that they shouldn't be, that money can go toward incentivizing companies through grants, or government contracts can preference companies who don't use database practices. There are other ways to encourage innovation in this space. It could be privacy and data protection could encourage innovation and not kill it the way some people would like to have you think.
So I would say the one study that I have seen that's really good on this question is actually on the e-privacy directive, and the best way to do this is to look before and after the implementation of a law, and then you do what's called the difference in difference analysis of various kind of features that you care about. This one was particularly interested in investment in the kind of the news platform ecosystem, and that was a reduction of 58 to 75% within the VC space. That wasn't necessarily looking at the returns, because that's a bit of a different question when you're talking about returns in a number of industries, and that actually kind of has some problems. But
you're talking about specific investment into that?
Yes, investment, VC investment. There was a depending on the way that you calculate the variables, the conditional variables, and we can talk about that if you're interested. But just depending on how that is calculated, it can range from effectively 60 to 75% decrease within that investment portfolio. And that doesn't mean, however, that it doesn't flow into other areas, which it probably could. And in fact, many times VC money does go into other areas. It's just the question is that specific sector did not benefit in the way it probably could have.
Which study is that? Oh, forget. I mean, the problem is that when e-privacy went into effect, e-privacy never went into effect. Nothing ever changed. Ad practices in Europe are still very much the same as they are in the United States, because Europeans don't actually enforce the privacy laws that they pass. So I don't understand that. I mean, I've seen studies saying that e-privacy was devastating, but e-privacy didn't actually change anything. I'll say from Consumer Reports' perspective, we don't actually take advertising. I will say also that the Digital Content Next, which is the leading trade association of publishers, is trying really hard to try to find ways to get them off of the behavioral advertising and Outbrain and Taboola crack that long-term is not great for the ecosystem to put people through these types of experiences. OBA still is a fairly small percentage of online advertising. There are lots of ways to do advertising. I don't think we need to sacrifice privacy forever because of these models that we at one point relied upon.
The one the one thing I have to at least push back on the effectiveness. It doesn't, one of the things that you talk about a lot in economics is expectations of inflation matter a lot for inflation. So expectations matter a lot when you're talking about investing within a specific industry. If you're expecting that you're not going to make as much, or that the industry is has some sort of expectation that there's a higher probability of loss, then that in itself can actually be a pretty big driver. Now, there may be other problems with the actual study itself, but at the end of the day, expectations, even if you don't have an implementation of a law, expectations can matter a lot. And I think the big way to see this is with Facebook. Facebook currently, or just recently, in the last year, has doubled the size of their staff in expectation that they're probably going to have to do more regulatory work here in the United States. Now, there wasn't a single law that was changed, but yet they themselves took upon a massive increase in the amount of people that they actually employed. Now, that's a clear change in expectation, driven by Cambridge Analytica and driven by, the hearings that were on in April. But
I think there are a lot of issues wrapped up into that.
Of course. But expectations matter a lot.
They haven't changed their practices.
Any other questions?
Yes. Hi. I'm Jen Lee from FPF, Future Privacy Forum. Daniel, you mentioned, correct me if I'm wrong, but you seem to be arguing that because consumers aren't willing to pay for privacy, that the privacy law is too burdensome and too expensive, and that's why you're against copying GDPR or even GDPR itself. But I guess like a direct harm that I would think of, touching upon Amy's argument, is on just direct harms of credit discrimination. That's being denied alone is a direct harm that you would not be able to gather directly from, your example from the German DVD store giving away a lot of your private information, and that those costs the cost that you might save might not directly align with the harms that you may incur upon yourself or other people. So do you think that a privacy law is important for bringing awareness into people's lives about the harms that can occur? And if not, what are some other ways to actually help people understand that, bridge the sort of knowledge gap there?
Yeah, I think privacy laws, I don't know if it raises awareness. It certainly, I think, scares people about privacy issues. I mean, when we looked at these surveys of kind of where people had concerns about privacy, it was largely tied to the countries that have more privacy laws actually tended to have a lot more privacy concerns. These laws aren't actually solving things. It's that I think people are seeing these laws and they get more concerned about their privacy and how their data is being handled. I think the way to address these types of problems, these kind of both the informational injury as well as these bigger harms like being denied a loan, are through what in the past were sector-based laws like the Fair Credit Reporting Act, which allowed provided consumers these type of protections. So if an adverse decision was made against them, they would have a right to recourse. They would be able to correct false information. There's certain limits on how companies can make decisions in this space. I think there are legitimate questions about asking, do we need to stop doing it in a purely sector-based approach and instead talk about certain types of sensitive data and regulating that data, so it's not just HIPAA and that applies to the hospitals and the insurers, but it's specific health data, and it doesn't really matter if that health data is collected on an Apple Watch or not, and we have some kind of basic guidelines around how that data is protected. I think those are the kind of important questions that could lead to a better debate in this area, and ask how we might modernize some of these laws as we have convergence in different industries, and that might help I think also simplify how consumers understand these issues, because they don't always understand well, why is my data protected if it's collected by a doctor but not when it's stored in this app over here. And simplifying that for consumers is, I think, an important and a legitimate problem that we could try and address with some of these laws.
Daniel, real quick, in the laws and fear place, do you have any evidence showing correlation as causation?
Not causation. We do, although we actually talk about that a little bit, because what we try to do is we looked at, so all the surveys are, as you know, like lagging 2 or 3 years. So we're going to have to wait on GDPR, but you can look at e-privacy and see changes. You can't go back to the older laws because that was kind of pre-internet. So there's not a good change point to compare to, but we can see that the trends aren't, aren't going down and they're not going up. So I think the GDPR question is going to be really interesting for Europe, because every year Eurobarometer has done this survey asking people what kind of privacy concerns you have, and it's pretty much stayed the same or gone down. So if GDPR doesn't substantially change European privacy concerns, I think there are going to be serious questions asked about, well, why did we go through this multi-billion-dollar exercise if we have this exact same concerns today that we had 5 years ago?
Possible answer to that question is that consumers' perception of risk is not a valid index of risk.
But it's the motivation for a lot of these laws.
Yeah, but it's not a valid index of risk, and presumably part of the motivation for the laws is to protect people from the risk they're actually incurring, not the risk that they perceive that they're incurring.
Yeah, but if you look at the debate on these laws, that wasn't the reason that these were passed. I mean, there was you didn't see European policymakers up there saying, well, we're seeing hundreds of $billion in losses and we need to prevent that, and with this law we're going to prevent that. They're saying consumers are complaining to us that they have concerns about privacy, and this law will address your privacy complaints. So, I mean, you could make that argument after the fact, but that's not what.
And not so much with the fundamental problem of protecting people from risk because of the way the data that's being collected from them is being misused.
All right, so unfortunately we're already 5 minutes over, so we're going to have to wrap it up there. But thank you again to our debaters and to the audience for joining us today.